Welcome to Campus Spotlight at WKCTC. Honored to be with you today, and really honored to have a special guest with us today. He's been a great friend for a long time. I met Judge Shea Nickell when he was in high school, and he was a starting football player, tackle on Paducah Tillman High School, a star player on some very great teams, and he graduated with my younger brother, and they played football together. And I've known him that long. His parents, great people, both teachers, dad a football coach. I played Little League football myself one time. Your dad was a coach. And so Shay's been a good friend for a long time. He graduated from Tillman, got his bachelor's degree from DePaul University, his law degree from the University of Kentucky. Then he was in private practice for a number of years and served as assistant county attorney for McCracken County, assistant Commonwealth attorney in Eastern Kentucky, and was elected to the Kentucky Appellate Court in 2006. So approximately 10 years he's been our appellate court judge for the Western District of Kentucky. So we're honored to have you, Judge, with us today.
Thank you, Professor. I'm honored to be here, and I certainly want to at first recognize my staff who make my job so much easier, and that would include my two staff attorneys, Carol Ulrich and Chad Curley, and also my judicial assistant, Debbie Staples.
Wonderful. Okay, Judge. Let's see, we're going to educate our viewers on the court system. First, would you provide our viewers with a brief overview of the Kentucky court system?
Well, the Kentucky judicial branch is a four-tier court system, and it's comprised of two levels. The first being the trial court level, which includes the district and the circuit courts, and the next two levels being the appellate courts, which includes the Court of Appeals and the Kentucky Supreme Court. Our current unified court system was established in 1975 with passage of the judicial article to the Kentucky Constitution. That fight was led, by the way, under then Governor Julian Carroll. It created the judicial branch as an independent branch of government, separate from and equal to the executive and legislative branches, and also from county and city governments. You and I may remember the days when we had city judges and the like.
Yes, I do. Before you describe the different courts, could you explain the difference between a trial court and an appellate court?
Well, both trial courts and appellate courts handle two types of law, first of all. One being criminal law, which involves cases where the government brings a criminal charge against an individual and a trier, either the judge or a jury, determines guilt. The other type of law is civil law, and those are cases between private individuals where the trier determines liability. And these cases also include administrative law cases. Now, trial courts are where cases are initially filed and they are tried. Both sides present evidence, whether through exhibits or testimony from witnesses, to support their version of the facts and what happened. Judges serve as the gatekeepers as to what evidence is appropriate. The trial courts find facts and then apply the law to those facts. Typically there's one judge who oversees the jury in a jury trial, or the judge himself or herself sits as the trier in a bench trial. Appellate courts, on the other hand, include no juries and only judges and or justices. They don't rehear the case. There's no additional evidence presented of any kind, and the judge or justices consider the case only from the official record of what was presented in the trial court. Again, it's not retried. Attorneys present the case through their written briefs and oral arguments addressing the legal issues, and the focus is on whether the law was applied to the facts accurately. The appellate court may affirm the trial court, may reverse, and in many instances may remand for further factual findings or modifications of the decision consistent with the appellate ruling. The appellate courts overrule trial courts only if a very important legal error was made. Lawyers simply argue legal and policy issues addressing how the law should be applied and interpreted. The appellate courts give great deference to the findings of fact at the trial court level, but no deference to the interpretation or application of the law. Appeals may be decided by one judge if the appeal comes from a lower court to another trial court, or in other times that it may involve one judge would be in emergency situations. But it's typically assigned at the appellate level to a panel of judges. My analogy, Professor Watkins, would be to the National Football League. You know, you have your referees who are down on the field, they're making the calls, and then you have your referees up in the booth who, when a play is challenged or a call is challenged, they send the video up there, and the judges or the referees there review the game film and review the law or the rule book and make their decision. It's been said that trial judges try cases in the heat of the day while appellate judges review cases in the cool of the evening, but definitely trial courts are where the rubber meets the road as far as the public perception is. In Kentucky, it's important for everyone to know that you have the right to one appeal. So if your case begins at the district court level, you have an appeal to the circuit court. If your case begins in the circuit court, you have an appeal to the Court of Appeals by right, no questions. If you appeal beyond the first level, your appeal is accepted or denied by discretion. There are certain criminal cases, particularly those involving the death penalty, life imprisonment, or sentences of 20 years or more that go directly to the Supreme Court. And then there are some other cases that upon proper motion or petition are accepted by the Supreme Court because they demand immediate attention.
It's very interesting, Judge. Could you now describe each of Kentucky's 4 types of courts to our viewers?
Sure. The district court is a court of limited jurisdiction, meaning that it only hears cases, the types of cases assigned specifically to it. In criminal law, it handles misdemeanors, that is, crimes punishable by up to 12 months in the county or local jails and fines up to $500, together with violations, traffic offenses, arraignments, felony probable cause hearings, and juvenile matters. In civil law, the district courts also handle city and county ordinances, probate of wills, voluntary and involuntary mental commitments, and cases relating to domestic violence and abuse. In civil law, they also hear cases involving $5,000 or less, and small claims involving $2,500 or less. Then the second level of the trial courts would be the circuit court, and it's a court of general jurisdiction, and meaning that it handles everything except for those specific things that are assigned to the district court or another court. And in criminal law, that involves felonies. That is a crime that's punishable by 1 year or more in state prison. It also includes capital cases, crimes that for which the death sentence may be imposed, for murder without mitigating factors but with aggravating circumstances. And alternatively, juries may also elect to impose sentences of life imprisonment without probation or parole, or life imprisonment without parole until 25 years have been served. The circuit courts also hear civil law cases. They handle matters involving more than $5,000, land disputes, and contested probate cases. They also hear divorces, adoptions, termination of parental rights. They also have equitable powers to issue injunctions or writs of prohibition or writs of mandamus to compel or prohibit actions by private citizens or the government. They also hear appeals from the district court and administrative agencies. One of the most important aspects of circuit court is the family law division. And here in Kentucky, the legislature has established family courts throughout Kentucky, and they handle everything related to families, and not only divorce, but custody issues, maintenance, property division, visitation, maintenance, anything that you would think of involving families, they hear in one court by one judge, so that there's some continuity between all the decisions that might arise. One circuit judge may serve more than one county within the circuit. Some circuits, however, have more than one circuit judge. Particularly here in McCracken County, we have 2 circuit judges and a family court judge serving the citizens. Mm-hmm. Then we move to the Court of Appeals, where I sit, and that court is exactly what it implies. It's nearly all cases come before our court. We have 14 judges who are elected across the state, 2 judges per judicial district. The other judge serving with me on the Court of Appeals from our district is Judge Donna Dixon. If a case is tried in the district or circuit court and the losing party involved are not satisfied with the outcome, they may ask for our court to review the correctness of the trial court's decision. Like I said, there's 14 of us. However, when we consider a case, we're assigned to panels of 3, and during the year we will serve with every judge on the 14 court, the other 14 members of the court at some time or another during each year. And that's to guarantee that there's not one conservative panel and one liberal panel, but just by luck of the draw, if you will, you'll get a diverse panel to hear your appeals. We don't sit permanently in one location, although most of our cases are heard in Frankfort or Louisville. We do get out in the state and hear cases in the circuit courtrooms across Kentucky so the people can see what we do. Then, of course, there's finally the Supreme Court, which is the court of last resort, the final interpreter of state law. And there are 7 justices that serve on the Supreme Court here in Kentucky, and they're elected, 1 from each judicial district. Of course, our Supreme Court justice is Justice Bill Cunningham, who's well known, well liked throughout our region and respected across the state. The Chief Justice is chosen by his or her colleagues on the Supreme Court, and they serve a 4-year term. That currently is Chief Justice Minton from Bowling Green. The Chief Justice is the head of the state court system, which is also known as the Kentucky Court of Justice. The justices on the Supreme Court sit as a 7-member panel whenever they hear cases in Frankfort. They hear direct appeals of cases involving the death penalty, life imprisonment, or imprisonment of 20 years or more as a matter of right. And then in addition, they're responsible for establishing rules of practice and procedures, including the proper conduct of judges and attorneys. They also oversee attorney and judge disciplinary processes.
Very good, very interesting. You mentioned Justice Bill Cunningham from Lyon County. I met him 30 years ago in my previous life when I opened up a karate school in Catawba, his home city, and his boys. He had about 5 or 6 sons, and most of them came to, or several of them came to the karate class, and that's how I got to know him. And he's a real gentleman, and does a good job, as you do. You're most popular. Next question for you: Do the judges or justices, do y'all have any insistence in providing justice to the public through the courts?
Absolutely, and I would be remiss if I did not mention certainly our circuit court clerks, who are responsible for managing the records of the circuit and district courts. There's 1 circuit court clerk elected in each Kentucky county, and they serve a term of 6 years. And then we also have assistants through the Kentucky Administrative Office of the Courts, which is headquartered in Frankfort. But they support our court facilities and programs in all 120 counties. It was established in 1975 with the enactment of the judicial article and they carry out the constitutional duties mandated to the judicial branch, which are quite extensive.
Here's a question I know a lot of people have on their minds when they have an issue to go before the courts. Is it necessary for an individual to have an attorney to represent their interests, whether it's criminal or civil court, before the courts?
Well, it's not necessary, but it is certainly advisable to have an attorney standing beside you, sitting beside you to represent your interest. Folks need to realize that judges and justices are referees. We are not advocates. Don't expect the justice or the judge to practice your case for you. I remember the old Boy Scout motto, be prepared. If you represent yourself, you need to be prepared. You need to understand that both the substantive law that applies to your claim, but also the procedural laws. If you miss a time restriction, your case may be lost. Unrepresented parties will be held to the very same standards as trained attorneys. The analogy that comes to my mind would be, would any person of a reasonable mind attempt to perform surgery, major surgery on themselves? I doubt that. They'd go to a surgeon or a physician. But neither the judges or the justices, and this is important, nor their staffs can render legal advice. I regret when friends call me these days and with a legal question, even if I know the answer, I can't provide a response. All I can do is refer them to local counsel of their choice, because a judge's responsibility and ethics will not allow him or her to render legal advice.
Mm-hmm. At the federal level, judges and justices are appointed by the president, confirmed by the Senate. I think about half of the states appoint, the other half elect. How are judges and justices selected, and how are they selected in Kentucky?
Well, in Kentucky specifically, we can go back to the very founding of our Commonwealth in 1792. When judges were appointed for life by the governor with Senate consent. Then beginning in 1850, judges came to be selected through a popular vote in partisan elections. But since 1975, Kentucky justices and judges are elected through nonpartisan elections. Now, judicial vacancies are filled by the Judicial Nominating Commission, which is headed by the Chief Justice. And this commission will choose 3 candidates from a pool of applicants, and they'll submit those names to the governor, who will then make an appointment. As you said, Kentucky differs from the federal court system, where the president makes an appointment which is confirmed by the Senate.
Mm-hmm. Good. What are the qualifications for a person to serve as a judge or a justice in Kentucky?
Well, first, if you don't apply, you don't qualify. So the first thing you have to do to become a judge is to file for the office and run in a judicial election. So you have to timely file your papers to be a candidate, and then there's a $200 filing fee, all of which has to be filed with the Secretary of State's office. Second, to serve as a Kentucky justice or judge, a person obviously must be a U.S. citizen. They must be licensed to practice law in Kentucky. They must be a resident of Kentucky and the district in which they're seeking election for at least 2 years immediately prior to taking office. Then in addition, the Supreme Court justices, Court of Appeals judges, and circuit judges must have been a licensed attorney for at least 8 years. District judges must be licensed attorneys for at least 2 years. And of course, to be licensed in Kentucky, one must graduate from an accredited college and law school, pass a strenuous 2-day bar examination, and also undergo a very thorough character and fitness review.
Wow. Are there rules governing the conduct of Kentucky's justices and judges?
Yes, and those rules are contained in the Kentucky Code of Judicial Conduct. These set out the ethical guidelines and principles for the conduct of all judges, justices, and even judicial candidates. I won't go through each of those canons, but basically they are intended to ensure the promotion of independence and integrity and impartiality in the judiciary, to avoid any impropriety or even the appearance of impropriety in the judge's activities, and also aim at having the judge or justice conduct their personal and extrajudicial activities in such a way as it won't interfere with their performance of their jobs.
Can a Kentucky justice or judge, if they sit on the Supreme Court, they're a justice, otherwise they're a judge by title, proper title, can a Kentucky justice or judge be removed from office?
The answer is yes. Kentucky judges and justices can be removed in one of two ways. First, if a complaint is filed by an individual or a group and a charge is thereafter brought after investigation, then after notice and a hearing, the Judicial Conduct Commission, which is appointed by the Supreme Court, may admonish, reprimand, censure, suspend, retire, or even remove a justice or judge. And this commission is composed of one judge from the Kentucky Court of Appeals, one district judge, one circuit judge, a member of the Kentucky Bar Association, and then two private citizens who are appointed by the governor. The commission's decisions, however, are subject to review by the Supreme Court, which may or may not accept the commission's recommendation. The second way a judge or justice can be removed is through a complaint filed and a charge brought after investigation in the House of Representatives, and then thereafter there being a conviction by a 2/3 vote of the Senate. I would also add that a judge or justice can be removed in Kentucky through the election process. You know, there are some states that don't elect their judges. They're appointed through various processes, as you've alluded to. But I think one of the great strengths of our system is that if the people aren't satisfied, they can remove the judge or justice at the end of each election cycle. In saying that, though, I would express a warning to people. Our citizens want judges who are fair and impartial and make their decisions based on the law. And when judges do that, folks need to remember that the judge may actually reach an opinion based on the law which he or she finds personally repugnant. But we are bound to follow the law, and the citizens have elected us to do that. Sometimes the decision is compelled because of a law that's passed by the legislature or the executive branch. But again, we are bound to follow that. So keep that in mind when you're evaluating your judges.
Yeah.
But the election process is an important check on all three branches.
And the legislatures can come behind and change the law.
Absolutely.
Next question. It's here nationally a lot. Justices and judges are sometimes criticized for making law rather than just interpreting law. What's your thoughts on that?
Well, as we alluded to earlier, sometimes the laws that are passed by the legislature or enacted by the executive branch can be vague, needing interpretation, and it may appear that the courts are coming to an interpretation contrary to what some may believe the law intended. But we try to discern the intent of the legislature and the executive branches and read and apply the law according to that intent. Whether a judge or justice is a judicial activist or, on the other hand, a strict constitutionalist often depends on the perspective of the party. In our nation's history, courts have been accused of being judicial activist courts from both sides, both liberal and conservative. So I think your perspective may impact your decision there. Judges often must weigh competing constitutional rights and other judicial goals in a single case. So, for example, religious rights might be involved in a case that also includes the right to privacy issues, or the right to an effective counsel may need to be weighed against the level of evidence in a case and the goal of achieving justice or a right decision. I'll also add at this point too that our courts are constantly striving to improve our services and improve the citizens' access to justice. And I want to provide two examples of that have come up in recent years. The first is the drug court program, which I believe the folks here on your program have heard about in the past.
Great program.
Which has one of the highest rates of success as far as turning people's lives around for the positive of any of our programs. It's more rehabilitative than punitive. And then also, just very recently, we have established veterans courts because we're noticing that a lot of our veterans returning home are having increased difficulty with the court system. One example from my experience long ago, when I was an assistant Commonwealth or assistant county attorney dealing with traffic cases, was I had several veterans who were constantly getting speeding tickets, and they just couldn't slow down. But when you look deeper, and they were losing their licenses, and then, of course, if you can't drive, you can't get to work, so they were losing their jobs. So a huge impact. But when we looked deeper there, we found that they were speeding because they had been trained to speed to avoid attack in the Middle East while serving our country. So we want to make our roadways safe, but we also want to serve our veterans and help them transition back to private life.
Okay. Last question for you. I know, and it's most important when we decide who we're going to vote for, but there are a lot of things you can't say in a campaign in Kentucky where we elect or for running for judge. So you elaborate on that a little bit.
Yes, judicial candidates can express opinions as far as hot button issues such as abortion and other types of issues like that, because those matters may come before us and it wouldn't be proper for us to express opinions. But it is important for citizens to elect good judges and also good legislators and executors who will fund and support access to justice through our court system.
And ladies and gentlemen, we have a great judge sitting right here with us. I've known him most of his life and can vouch for his honesty, integrity, his intellect, his energy, and his work ethic. And I'm honored to have Judge Shea Nickell, my friend, and a great appellate court judge for the Commonwealth of Kentucky here with us today. So thank you, Judge, for being with us.
Thank you.